This is Michael Popok, and by the look of things, it must be time for Legal AF After Dark. Judge Aileen Cannon, or what I like to call Cannonball. You know, like the kid at the pool that jumps in and gets everybody wet. Judge Aileen Cannon is making a series of decisions that are making sort of a mess of the trial, of what should be the trial of the century against Donald Trump, related to, as indicted, his wrongful and criminal retention of national security information, classified information, top secret information, and obstructing justice along the way. But in Judge Cannon's hands, nothing is as it seems. You have to read the tea leaves of her docket entries, what she does in court, how she's progressing or not progressing the case, and what that all means, and what are the 11th Circuit bosses, the appellate bosses of the trial judge Aileen Cannon, going to do with her and the problem that she's become should Jack Smith, special counsel, file a motion to disqualify. We break it all down for you. If that piqued your interest, on a show we call Legal AF on this MeidasTouch network. Take a listen.
Michael Popok. So Judge Aileen Cannon set a hearing for next week, March 14th or March 15th, but end of next week, she set a hearing date where she wants to hear these motions that are brought by Donald Trump, very frivolous motions to dismiss the indictment in the Lago document case. Judge Cannon also accepted amicus briefs from literally the Citizen United group itself and from Stephen Miller. And Stephen Miller's entity is the group that goes around suing corporations for discriminating against white males. And Stephen Miller submitted a brief saying that there is no jurisdiction under the Presidential Records Act for Judge Aileen Cannon or any judge to even render a decision, and thus the case needs to be dismissed. There's also a constitutional vagueness motion to dismiss, just a completely frivolous argument. Trump's essential claim for trying to dismiss the Mar-a-Lago document case, where Trump willfully retained national defense information, including nuclear secrets, war plans, and some of our nation's most sensitive documents. Trump's filings say that these records belong to him, that they're his personal records. So he's not only arguing that he telepathically declassified the records, he's also saying that he converted the records into his own personal property. So he says that simply by packing up our nuclear codes and classified information, putting it in a box, and then shipping it to Mar-a-Lago, that then makes these documents personal records, and it belongs to him, such that he claims, and this is what Stephen Miller's amicus brief touches upon, and this is what Judge Aileen Cannon said could be helpful for her rendering her decision, and then there will be oral argument on this at the end of next week, that Trump claims that it now belongs to him and there's therefore not jurisdiction. Special counsel Jack Smith filed a fiery response saying that is just so utterly absurd. Let me just pull up one of Jack Smith's comments here as well. By the way, that hearing is March 14, 2024, that Judge Aileen Cannon has set. And this is basically what Jack Smith writes. He goes, defendant Donald Trump moves to dismiss the superseding indictment based on the Presidential Records Act. Trump's claims rest on three fundamental errors, all of which reflect his view that as a former president, the nation's laws and principles of accountability that govern every other citizen do not apply to him. First, the Presidential Records Act does not affect the scope of the statute that Trump is being charged with that underlies those counts. The section prohibits the unauthorized possession and willful retention of national defense information, even if the raft of highly classified documents that Trump took from the White House to Mar-a-Lago were somehow categorized as personal under the PRA. That would not render his retention of those documents authorized. Second, the charged documents are indisputably presidential, not personal, and Trump offers no basis to conclude otherwise. Instead, he contends that because he transferred documents to Mar-a-Lago rather than to the National Archives Records Administration, the court must conclusively presume that he designated the documents as personal, despite contrary allegations in the superseding indictment, the presidential nature of the records, and his own public statement saying the opposite. He further contends that an implied decision to treat records as personal personal lies beyond the scope of judicial review. I just wanted to read that, Popok, because I don't want you to just to think that, oh, this is like Ben and Popok's spin on what Donald Trump is arguing. Trump is actually arguing that our nuclear secrets are his own personal records now because he shipped them to Mar-a-Lago. The fact that Judge Cannon's not just rejecting this on the papers and that she set a hearing on this and invited Stephen Miller's brief saying that this should not be within the province of her. I mean, just it's so typical Judge Cannon. Let me hear from you there, and then let's just talk about, like, her docket is a total mess now. She hasn't set the trial date. She hasn't ruled on SEPA issues. I've never seen a messier docket, yet alone a more corrupt docket, but just a freaking messy document in my legal career. Michael Popok, what say you?
And you're not even talking about the things that aren't on the docket that should be. She's created a secret shadow docket where she's made Jack Smith have to cross a hurdle that I've never seen in my years of practice in federal criminal law and defense. She requires him to serve her, email her the document and Trump's side before it goes on the docket. This from a judge who says that she is the protector and of all things transparency related to a criminal process. She's created her own secret docket, and that's why you and I are always a little bit late in revealing what filings look like, because they're not hitting the public docket even in redacted form. I'm going to have an interview that's going to be going up, I think, this weekend, early next week. We're having Judge Ludig back with us, conservative, Federalist Society, Republican, a constitutional scholar and patriot who has his own issues, including with Judge Cannon, and he'll comment on that. He'll give you his opinion about what is happening with the United States Supreme Court with their late decision to hear immunity and whether that's going to impact the ability to even have a trial with Judge Chutkan in the D.C. election interference case. Judge Cannon, it's odd, and I invited Judge, you'll hear it in the interview, I invited Judge Ludig, who's been the author of a number of very powerful and persuasive amicus briefs to the United States Supreme Court and the D.C. Court of Appeals, to start filing amicus briefs and flooding the court with his amicus briefs in Cannon's case, because Cannon, to have her say not just approved on the amicus, but she thinks it would be helpful to hear from MAGA right-wing non-lawyer Stephen Miller and a right-wing MAGA podcaster in their positions on the proper application of the rules related to the National Archive and whether Jack Smith was properly appointed and properly budgeted by under the appointment clause of the Constitution. I started reeling that out to Judge Ludig, and he was like, "What?" I'm hoping he'll take us up on our proposal that he starts sending in amicus to her as well. And I see Jack Smith's, one of his responses is he's beefing up his team. He's adding people from the D.C. election interference case, which may not be happening in any time soon, like Jim Pierce, who's his trusted right-hand prosecutor, adding him to the team as they gear up for the 11th Circuit appeal, the inevitable appeal to the 11th Circuit on one or more reversible error moves by Cannon. You said, I think you called it a Cannon mistake or another Cannon move. I heard cannonball. It's another cannonball, like when you were kids jumping into the pool. And she just does it over and over again. She's about, I'm pretty sure, to make a reversible error, fundamental injustice ruling related to the disclosure of witnesses on the public docket. That motion for reconsideration, as reported, that she held to let Jack Smith have one more chance to convince her not to make reversible error, not to do that, from the reporting inside the courtroom, didn't go well for Jack Smith. And if she comes down and says, no, I'm going to double down, the problem with her is when you put her into, she gets her backup, and which is exactly what you're not supposed to do. And that is grounds to remove a judge when they're starting to defend their own position, not because it's reasonable, not because it's well thought through, but just because. And she's getting into that just because world, where it's always, the prosecutors are always wrong, Trump is always right, and she doesn't like being challenged, which is the problem with a not confident, immature federal judge who hasn't been around the block enough and has a temperament issue. And more I see of her in this proceeding, the more, rather than sit back and say, I don't really know this area well, let me learn, let me read briefs, let me listen to the government's position in a sober fashion, let me have my law clerks do their job and go do some great research. Her natural instincts in this area, as you outlined, are terrible. She doesn't have the natural instincts that come in this area. And when in doubt, she bends over backwards, apparently, to help Donald Trump, including that you and I are even talking in March of 2024 about indictment dismissals that should have been filed 9-10 months ago to allow for a proper briefing and appeal. She's screwing herself as well in her setting the order. Her order setting the briefing schedule. She's having the reply briefs, which is the final word on the issue. These 3 motions to dismiss she's going to hear on the 14th of March. She's having the reply brief come in at 8 a.m. in the morning, and she's holding the hearing at 10 a.m. Well, how is she going to possibly sift through a 20-page reply paper and all the new case law and then hit the bench to have a meaningful hearing? It's as if she does, right? It's as if she doesn't care any longer. Look, the quicker she makes some fundamental ruling and the quicker Jack Smith can get up to the 11th Circuit, the better. The question is going to be, will he ask for her removal and will they grant it? And Judge Ludig, in my interview, has an opinion, having been a 4th Circuit Court of Appeals judge, about both of those issues.
Well, I'm glad that we have Judge Ludig coming in and consistently giving commentary now here on the MeidasTouch Network. I'm excited to watch that interview. When I was talking about the possible the date of this hearing, it was the 14th. But if you go back and look, I was saying, I'm like, the 14th or the 15th, because I saw it was the 14th, but I was like, aren't the reply papers due the same day?
Right.
You know, and I'm like, how's she having the reply papers due on the hearing? And it is the same date, as you clarified. But here's the thing. This should not be a political issue when it comes to Donald Trump claiming, or anyone claiming, that the nuclear codes and classified information that belongs to we the people, that should be held in the highest of secretive silos and gifts and all of that. Donald Trump claims that it is his. Trump's argument in this case now, after 20 different iterations of lies, starting with the FBI planted the documents. Y'all remember that's how they started this. This stuff was planted. And then it evolved to now his argument is, I did it. I took it. But they're mine. They're mine. I had the right to take it because when I put things in a box and I send it to Mar-a-Lago, they become my own personal property, and you have no right to question the fact that I've claimed all of these American documents as personal. Now, if you take that by extension, that means that he could basically say the Capitol building belongs to him. That's his personal property, right? He can say Washington, D.C. belongs to him. He would say that's his personal property. It's the dumbest and most dangerous possible line of inquiry when you break it down in that way. You know, and then they want to talk about, well, Clinton did it. Bill Clinton. It's the Clinton Sox case. So it's like the Sox. And it's like, no, it's nothing like the Sox. You're saying that a case that was filed, again, by a non-lawyer who runs the right-wing MAGA judicial thing, not Stephen Miller, Tom Fitton, or whatever the guy's name, who wears the really tight shirts like that. He sued the National Archives and lost when he sued them in like 2011 and 2012 to basically force the archives to go back in time to 1999 and get Bill Clinton's personal handwritten notes that Clinton prepared for Clinton's personal autobiography. It was a district court case that the MAGA lawyers lost. It's not a circuit court case. It's not a Supreme Court case. It's not precedent. And that's what they're citing and claiming as a justification for this idea that classified records belong to Donald Trump. And then they go out and go, Clinton socks, Clinton socks, Clinton socks, Clinton socks. And then the media, they want to both sides it. The info doesn't get out. And it's like, what? No, this is what are you talking about? It's like the stupidest freaking argument in the world.
Well, there's one example of a show we do, and we named it on purpose, Legal AF. It wasn't an accident. It means exactly what you think. We take about 4 or 5 different segments just like that one. We curate it in a show just for you. And then we break it down and catch you up during the week in hot takes, just like this one at the intersection of law, politics, and justice. If you like what we're doing, you've never seen our show before, welcome. That was Legal AF. I am Michael Popok, and we welcome you to join us. If you know all about us already, and you're already part of the audience, we thank you for being there as part of your journey on our journey. And we ask that you take that clip, it's bite-sized, send it off to friends and family, people in your life, and say, hey, you know that show Legal AF I like a lot? Here's an example of it, and see if we can get them to join the audience. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.